Hello, welcome to our webinar, Understanding Potential Cybersecurity Risks and the Paths to Compliance in Korea. Today, we will get an overview of some of the latest developments in the cyberspace, ably provided by speakers from Lee and Co. As we will shortly hear, cyber incidents ought to be treated as internal investigations, and one of the most valuable parts of the response to any incident is the lawyers. Lawyers have the skills to lead and manage an investigation. They can mediate discussions between security and IT professionals and the board, and that tends to get overlooked. So we will correct that by exploring some of the practical issues that surround cybersecurity incidents today. We will be hearing from, as I said, three wonderful speakers from Lee & Co. We'll be hearing from Mr. Kwang-bae Park. Kwang-bae Park is a member partner of Lee & Co. and the leader of the TMT group at the firm. He has consistently represented and advised the various telecommunications and IT companies of the region for more than 15 years. In the TMT space, for example, he has successfully represented SKT and SK Broadband before the Korea Fair Trade Commission and Korea Communications Commission on serious anti-competitive risks related to their merger. He has also advised and represented eBay Korea on the various regulations and liabilities it faced as an operator of internet platform and advertising businesses. He has helped Google with the localization of its services in Korea and helped Korean Airlines on the introduction of what was at the time the largest ERP outsourcing project in Asia. So very much looking forward to hearing from him. We will also be hearing from Kyungmin Son. Kyungmin is a partner with Lee & Co. who specializes in TMT-related laws and regulations such as licensing, interconnection, and privacy protection issues, representing domestic and international telecommunication companies, media companies, and financial institutions. Mr. Son's expertise also extends to M&A transactions, including share purchase, asset purchase, and other corporate matters. And completing our lineup today, we will hear from Jong-Sob Park, who is Chief Expert Advisor at Lee & Co. Mr. Park is a reputed information security professional with extensive experience in both Australia and Korea. He began his career as an ethical hacker, in inverted commas, an ethical hacker at Ernst & Young Australia, where he advised on technical security consulting and IT assurance. He later served as head of Asia Pacific Information Security at eBay, and there he was responsible for security management, governance, and crisis management, among other things. Mr. Park was also one of the key facilitators of the extreme hacking and ultimate hacking courses, I'm sure you know, two very well-known courses in the Asia-Pacific region. He not only designed the course, but also instructed clients from a number of public and private sector organizations on them. He is now a Chief Expert Advisor at Lee & Co. We are very much looking forward to hearing his thoughts. So with that, I will pass over to you. Okay, Kwang-bae, you are on mute.
Thanks, James. This session we will discuss with and give you some insight into the data breach and privacy infringement in South Korea. In this session, we will discuss 4 items, but actually the key part of our session presentation is mainly focused on the analysis on the data breach and privacy infringement in cases in Korea. But in order to do so, we will very, very briefly overview on Korean data protection regime. And also after the analysis of the data breach and privacy infringement cases, we will briefly look at how to respond to the personal information leakages. And then finally, we will also discuss with some designation obligation of CPO, CISO, and domestic representative, which obligation is all the time, sometimes a headache to foreign companies. So we will discuss a little bit later because their role and responsibility is related with data breach and privacy infringement. Already James has introduced myself and the speakers. I will pass on this explanation about three speakers. And Lee & Go, probably you may or may not heard about Lee & Go. Lee & Go is one of the largest law firm in Korea, and our TMT and DPC data protection and data privacy and cybersecurity practice group has been practiced almost 20 years or more. So simply, that's all. And if you have if you need further information, we are welcome to visit our website. Okay. Now I move to chapter 1, a very brief overview on the Korea data protection regime. In Korea, we have a general data protection laws, which we call the Personal Information Protection Act, or PIPA. PIPA is actually more than 100 provisions, and it was enacted in 2011. And it's almost 10 years of here in Korea. But we have also another sector-specific laws. Among various laws, we have picked up several sector-specific laws which we believe is important for the foreign service provider or foreign companies. First one is the Credit Information Act, which is applicable to the processing of personal credit information. Clearly, it is applicable to the financial institutions, but even though it is not financial institution, but you may process personal credit information, then you are also subject to Credit Information Act in Korea. Let's say kind of rental cars, rental companies, maybe they also need to use the personal credit information. So to that extent, the Credit Information Act will be applied. Another important law is that the Location Information Act. Korea is the only country in the world who have a separate independent Location Information Act. Location Information Act is mainly two parts. One is a kind of license part, and the other one is the data privacy of the location information part. So when you're handling processing the location information, then yes, you should be cautious about whether you are comply with the Location Information Act. And if you have a kind of a telecommunications or side, then Communication Secrecy Acts will be applicable. And if you are in the medical sector, yes, medical service agreement and other several laws will be applicable. And the next, the Network Act, or Information Communication Network Act, which was previously applicable to information and communication service providers. In other words, it is applicable to telecom companies, media companies, and other online service companies are all subject to Network Act. Until the big amendment to the PIPA Network Act and Credit Information Act in last year, 2020. There was big changes, and then it has structurally changed the Korean data protection regime. For a little bit more is that from August 5th of 2020, PIPA actually working as a general data protection laws, and so it is applicable to all legal entities and organizations or individuals if they process personal information for businesses. But the provisions, specific provisions of the privacies under the Network Act has moved to the PIPA, from the Network Act to the PIPA, and PIPA actually created a special chapter under the name of special treatment on the ICSPs. ICSP means the Information and Communication Service Providers, and actually, easily speaking, online service providers. Yeah, but other laws are okay. Credit Information Act, yes, there has no structuring changes, but last year's credit information has been substantially amended. So they are very complicated and getting more complicated than before. And even though I said if you are credit information institutions, financial institutions, then you are subject to supervision of the FSS, Financial Supervisory Services, or Financial Service Commissions. But if you are non-financial institutions, but your process is personal credit information, then PIPC, Personal Information Protection Commissions, will be your governing supervising authorities.
One of the remarkable characteristics of Korean privacy law is that Korean law requires very specific technical and managerial security measures in the forms of standard. The standard sets out quite wide range of security safeguards, including but not limited to internal planning and documentation, access control to personal information managers, organization, encryption, logging, and physical security. Since the latest amendment to PIPA in 2020, where the provisions within the Network Act relating to personal data processing of ICSP were moved to PIPA, now two separate standards were established pursuant to PIPA, one for general personal data handlers and another for ICSPs. As you can see in the slide, the coverage of both standards has more similarities than differences. Although it's not shown on the slide, perhaps the most outstanding difference would be the applicability of individual requirements, depending on the number of data subjects that an organization is handling. More precisely, data handling organizations are grouped into three types, which has less than 10,000, between 10,000 and 1 million, and more than 1 million. Then stricter requirements are applied to groups with larger numbers. The purpose of the standard explicitly states that the measures are only minimum requirement, which means they are necessary conditions, not the sufficient ones. The requirement has been utilized as a powerful yardstick for technical compliance of privacy, especially for the cases of data breach. Later in this session, I'll go through some examples showing how TOM requirements were applied to data breach cases.
Now we will move to the main portion of this session, analysis of data breach and privacy infringement case. We will discuss with 4 cases. Actually, there are lots of data breach cases and privacy infringement cases in South Korea. We have a look at the last 5 years of cases, and we have selected 4 cases. 2 is mainly related with data breaches. The other 2 is mainly related with privacy infringement. So, and we also think about that the typical cases could be useful for the foreign service provider or foreign companies to have a better idea on the practice of the data in relation with the data breach and privacy infringement in Korea. So let's move on. First case. This is a hacking incident. And actually, there are many hacking incidents in Korea. Interpark is one of the major e-commerce sites in Korea. This case was happened in 2016, and this case is related with the social engineering attacks by the hackers. Hackers, probably we presume that that hacker is not from Korea, and that hacker still we don't know who it is. He appears to access to the private email account of the employee, one of the employee of the Interpark. That email account is that the account from Naver.com. Naver.com is a Korean version of the Google.com, simply speaking. And he can, we don't know how he can obtain the ID and password of the employee A of the Interpark by the hackers. But anyway, he was successful to access to the mailboxes of the employee A of the Interpark, and he have a chance to look at the various emails from the employee A and his younger brother, and he was able to get family photos between them or the SNS site. So, and then hacker actually sent a screensaver file to employee A. And in doing so, he is pretending that it was being sent by employee A's younger brother, his younger brother. And that screensaver file was made of the family photos. So, and the hacker actually imitated the younger brother's way of speaking, and he also disguised his email address as if he is from younger brother. So if you are that employee A, what would you do? If it was me in the case, then I also will click that attached file. So once he attached the screensaver files, then the hacker actually gained a foothold into the Interpark network. So once he get access to the employee's personal computer, then he can scan the internal network of the Interpark, and also he can remotely access to the database manager's personal computer, and then he eventually log into the main database DB servers of the Interpark, and he actually take out the 25 million of the users of the personal information on May 5th of 2016. May 15th is that the Children's Day in Korea. That means it's a holiday. And those periods are holiday seasons. And actually, the Interpark never knew that this hacking incident until 1.5 months later, they received a blackmail from the hackers. And the hacker actually demand that to send a Bitcoin equivalent to 3 billion Korean won, or similarly, 2.37 million US dollars Bitcoins. And Interpark refused to do so, and then they reported to the police, and then this accident pops up in the public in the later stage. And actually, in this case, KCC, the data protection authorities at that time under the Network Act, has actually investigated Interpark whether there is a kind of the breaches of a failure of the compliance on the TOM, technical and organized measures, by the Interpark, and because of that, the personal data was leaked or not. They have investigated, and they eventually imposed an administrative penalty of approximately 4 million US dollars, and some technical failure of the compliance. They also imposed 20,000 US dollars of the administrative fine. And Interpark ultimately appealed to the court of such a decision of the KCC. But unfortunately, Interpark ultimately lost the case. And in this session, we will discuss two cases in relation to the Interpark. One is administrative court cases. The other is civil court cases. Civil court cases are raised by the complaint users, and they raise for damage claims against Interpark. But this administrative case is Interpark raised appeals against the KCC's decision. And the administrative cases, Interpark, there were the three issues with main issues. Where first issue was whether Interpark failed to implement or violated any TOMs. Second issue was whether the causal relationship is required between the Interpark failure to implement the TOMs and the leakage of the personal information. Third one is what is the standard for calculating administrative penalty amount? That is the main issues and in this administrative ruling.
A number of technical controls were identified incompliant during the KCC's audit. Especially two issues were seen as major violations because the issues became critical vulnerabilities, which later turned root causes of the incident that the attacker abused during the intrusion. The first issue was inactivity timeout period. TOM requires that personal information managers' access to the personal information processing system is automatically terminated after a certain period of inactivity. The idea is to prevent an intruder riding on a live authenticated session of an authorized user. The timeout period of inactivity is preferably set to 10 minutes or less. Unfortunately, Interpark's configuration did not meet the standard, and the IT staff left the PC with the access session to a database server live. Consequently, the attacker was able to take over the existing session and gained unauthorized access to personal information database. The second issue was that Interpark failed to comply with the password management guideline the standard requires. The IT staff, who was the first victim of the attack, stored a number of administrative credentials, including the shared administrative account, which later apparently used by the attacker. The credentials were written in plain text file and found in a shared folder. Even worse, the IT operation team of Interpark were using a password register for a list of servers and password protect the Excel file. However, password of the Excel file was written in human readable form in another unprotected text file, which made all of the access control and encryption effort meaningless.
Now we will discuss important legal issue in administrative case. Whether there must be a causal relationship between the TOM's violation and the leakage of personal information. Because it is very difficult to prove causal relationship, the outcomes of a lawsuit usually depends on who bears the burden of proof. HIPAA stipulates that a leakage of personal information and a failure to implement the TOMs just end, not as a result. So the administrative court judged that regarding administrative penalty, no causal relationship is required. So PIPC does not need to prove causal relationship in order to impose administrative penalty. Please note that there is a difference with civil liability. We will discuss soon. Next legal issue, how calculate administrative penalty? Practically, this is a very, very controversial issue because the administrative penalty can be greatly increased depending on the calculation criteria. And the main criteria is information and communication service related to the violation, which means any service that is directly or indirectly affected. four main factors are considered: method of providing the service, method of signing up for the service, scope of service, and organization of database systems. Not only PIPC, but also administrative court interpreted this concept very widely. The court ruled that it cannot be interpreted as a gain or revenue from the violation itself. Based on this interpretation, product sales from a website included, but performance earning and rent that are not generated from the user website, this kind of revenue is not included.
Sorry, guys, to interrupt, but you are all on mute. Kwang Bei. Okay, thank you.
Sorry. Now we are checking the related civil rulings in Interpark case. The civil court pleaded liable for damages of 100,000 won to each data subject. As you may know, in Korea, damages shall be calculated based on the data subject, who is plaintiff. There are two major issues in a civil case. First, whether a causal relationship is required. Second, scope of liability. Now we will discuss a causal relationship in civil case. TIPA's stipulated damages provision stipulate that if personal information is leaked as a result of willful misconduct or negligence, so court ruled that causal relationship is required in civil case, which means that plaintiff has to prove the causal relationship. Please remember to compare in administrative case, causal relationship is not required as explained before. Second, calculation of damages. TIPA's statutory damage provision stipulate that up to 3 million won. However, in this case, court recognized 100,000 won because the personal information was encrypted and no additional infringement. This is difficult to perfect, technical perfection in preventing the leakage. So despite the statutory damages provision, the court has discretion to calculate damages.
Now move to second case. This case is data breach case is actually the largest ever, biggest data breach cases in South Korea until now. And this case is mainly data breaches by outsourced service providers employed. So it's all the time it could be an issue if you hire or retain some outsourced service providers. And this actually case was happened in between the data breach itself was done between 2012 to 2013. And actually, the early of the 2014 January, the local prosecutor's office announced that they found that and they arrested Mr. Park, who is the employee of the KCB, because he take out the lots of the personal information from 3 credit card companies. So there are more than 10 credit card companies in Korea, but these three credit card companies are major one. And the Mr. Park here, Mr. Park at the KCB has taken 25 million customers data from NH 농협 card and 43 million customers from KB 국민 card and 26 million customers from Lotte card. In Korea, we have a population of 51 million. So if you get a total, that it is more than 100 million personal data was leaked. Lately, it was found that there is some duplications, but still they are closely to 100 million personal data was leaked. And considering that there are 51 million Korean population, and most of the Korean the people in and closely actively working class of the salarymen, whatever, they have typically 4 or 5 credit cards in their hands. So many people actually have double or triple the leak, their personal data was leaked. And why they have outsourced that? Because the KCB actually provided and developed fraud detection system for credit card companies, and because of that, Mr. Park actually has to dispatch the 3 credit card companies, and he has to work with closely in the premises of the credit card companies. And doing so, he take out using US device, he take out those personal information from the credit card companies. But he actually, after that, he saved those information in his personal computer at his home, and then he selected some of the personal information and provided to advertising agencies, and then advertising agency also sent to loan solicitors, and the money was returned back to the advertising agents to Mr. Park at KCB. But there are other companies, other credit card companies, where the Mr. Park also worked for those FDS projects, such as Samsung Card or Shinhan Card. Mr. Park wasn't able to steal the personal information of the credit customers due to companies' encryption programs and other TOMs. So it was kind of something. Some credit card company was personal data was leaked, some not. So it was big issues at that time in Korea. And this case also, there is administrative sanctions, but also it has litigation. One is the criminal litigation cases, and the other is the civil damage claims from the data subjects. In the case of the criminal cases, Mr. Park himself, he was actually imprisoned and sentenced and actually sentenced for 3-year imprisonment. And this case is this is not related with Mr. Park. This is related the 3 credit card companies themselves are indicted or prosecuted as their criminal violation, because if they under the law at that time, and even it is the same, if you fail to comply with the TOMs, and as a result of that, the personal data was leaked, then the company itself or someone who is in charge of the company may be subject to 2 years imprisonment or 10 million Korean won of the criminal penalties. Anyway, typically it's not common, but in this case, because this case was so huge and so powerful in Korean society, this credit card company was prosecuted by the prosecutors. And the three issues in this criminal case was raised up. First one was whether credit card company themselves failed to implement or violate any TOMs. And the second issue is whether they have complied or failed to comply with their obligation of outsourcer to supervise the outsourcee. And third one is a causal relationship between TOM violations and Mr. Park's leakage of the personal information.
In this case, Korean court judged that card companies failed to comply with several TOM requirements. Firstly, the card companies allowed external project team to access credit card information and download them on notebook computers without proper access control. Mr. Park used USB memories to copy credit information from the notebook's shell folder and take out freely by utilizing weak physical security controls. At the time of the crime, the card companies did not install or verify the installation of security software on Mr. Park's notebook computer. If such controls were in place and performed properly, it could have prevented such illegal activities. Moreover, the card companies supplied credit information in unencrypted format, violating encryption requirement, which demands strong encryption algorithm be used against particular identification data at rest. The next issue was negligence in supervising outsourced tasks. Similar to the concept of data controller and data processor, PIPA explicitly state obligations imposed to outsourcer and outsourcee of personal information. Conceptually, a data outsourcer is the party who provides personal information to an outsourcee for its own business purpose and interest, while as a third-party provider is a party who provides personal information for receiving parties' business interest and purposes. PIPA requires outsourcer to educate and supervise outsourcee to handle personal information in compliance with relevant laws. An outsourcer is liable for damages incurred by outsourcee if the outsourcee violates PIPA in handling personal information while performing outsourced tasks. In this case, the credit card companies are judged to violate obligation of supervision as an outsourcer and also violated obligations imposed on as a data handler.
I want you to remind that in civil case, not administrative case, the causal relationship is required. And regarding criminal case, causal relationship is also required. Then what is the meaning of the causal relationship in criminal case? Criminal court ruled that failure to carry out the TOMs does not have to be the sole or direct reason for the leakage. And an ordinary person was able to easily predict that someone could leak if company failed to implement the TOMs. We said this kind of causality as substantial causal relationship. Sum up, in criminal case, prosecutor shoulder the burden of proof for causality, but the causality interpreted not so narrowly. So it is not low likelihood to incur criminal liability. Related civil rulings. Companies were required to pay damages of 100,000 won 100,000 won for each customer whose personal information was leaked. The damages are quite similar to Interpark case. So the Interpark case and these three major credit card cases recognized as the leading case regarding calculations of damages. Let's discuss major issue in civil case. First, basis for imposing liability. Second, scope of liability. The first issue in civil case is basis for imposing liability. Before I go into detail, regarding data breach, three damages claims available in civil case. Damages based on the general tort, and statutory damages under PIPA, and punitive damage under the PIPA. Then please compare civil code and PIPA regarding burden of proof of willful misconduct or negligence. Civil code, the data subject must prove the data handler's willful misconduct or negligence. However, in PIPA, the data handler must prove that there was no willful misconduct or negligence. So, on the PIPA, plaintiff do not need to prove the data handler's negligence. In this case, court ruled that the three credit card companies and KCB all violated the TOMs and admitted their joint and several liability. After the above ruling, the PIPA was amended to include statutory damages provision and punitive damage provision, which allow up to 3 times the actual damage suffered by the data subject in case of gross negligence or willful misconduct. For your information, in Korea, punitive damage is not generally accepted, but some special areas such as data breach case can be applied punitive damages. The second issue in civil case is scope of liability. 8 factors to be considered that calculate the damages. Type and nature of leakage personal information, likelihood of the data subject being identified, how widespread the leakage is. And please note that the last one, measures taken by the data handler to prevent damages and prevent the spread of damages. This shows that how important you handle data breach accident, data breach accident.
Now we move to third cases. From these two cases, third and fourth cases mainly related with the privacy infringement cases. And Facebook case is the most recent cases actually happened and rendered by the PIPC. The Facebook, maybe most of you, the audience may have accounted Facebook, and this case may be similar to the other jurisdictions, but anyway, the Korea has very strong and stringent regulation, especially in terms of the consent from data subjects. So when you transfer or provide personal information to third parties, you need a separate consent from the data subject. And the PIPC found that the Facebook failed to get obtaining proper consent from the data subject, Facebook users. The case is very simple. The Facebook actually user signed up for and log into third-party app using his Facebook account details. So like Facebook logins or Google logins, or if you're in Korea, there's Naver logins or Kakao logins. So SNS provides various login services. So simply login process, the Facebook actually send, doing so, Facebook provided personal information of not just third-party app developers, but they also included that the Facebook users' friends information, and that information contains the profiles or relationship status, education, work experience and activities, and country addresses, blah blah blah. This incident was done through from 2012 to 2018. I mean, for 6 years, Facebook has transferred to those friends, Facebook users' friends information to the third-party app developers. And the data about it is known as 18 million Facebook users in Korea, and among them, 3.3 million personal information has been provided to third-party app developers. And there are more than, maybe that depending on the situations, a little bit the number is changing, but based on the announcement of the PIPC, that it could be the third-party app developers are more than 10,000 developers in terms of this case, Facebook's violation. The PIPC, this case is because it was rendered last November 25th of 2020, so there is no court cases yet. But we are purely based on PIPC's finding, and the final maybe decisions, maybe we think that the court will be rendered in any way. Actually, PIPC actually imposed about $6 million of the administrative penalty and about 60,000 administrative fine. And also they referred this case to the criminal investigative agencies. Under the Korean law, generally, if you fail to get a proper consent from the data subject, maybe it can be data consent from sensitive information, it can be consent from particular identification information, or there are many consent requirements are imposed against the data handlers in Korea. And if they fail to do so, in many of cases, they may also subject to criminal sanctions. And because of that, the PIPC actually referred this case to criminal investigative agencies. And what was the issues typically in this PIPC's administrative disposition? It is 3 issues are being popped up. First one was the applicability of the PIPA to foreign service providers. And second one was that the provision of the personal information to third party without data subject consent, even in case of the friends of the users. The third one was that whether it amount to the refusal to cooperate with the PIPC's request for information and material production, and whether there is interference with the PIPC's investigation. First one is that the extraterritorial application of the PIPA to the foreign service providers. Actually, there is no explicit provision in the PIPA regarding extraterritorial application like the GDPR. But the PIPC found that and actually said that when it comes to data protection, the basic direction of the PIPC is to strictly enforce laws against the violators, regardless of whether they are Korean entities or foreign service providers. So PIPC made it clear that the PIPA will be also applicable to foreign service providers who provided who process the personal data of Korean nationals or Korean residents. And this position is not something new because that the formal the regulators KCC also has imposed similar administrative sanctions against the foreign service providers. For example, in 2014, the KCC actually imposed about 190,000 US dollars of the administrative penalty against the Google Inc. in the United States. This is typically known as street view cases, and you may know probably about this case. And another case is that the KCC, if just before August 5th of 2020, I mean, they are at the time, the last July 15, at the time they are still the data protection authorities in charge of the online service sector. KCC rendered the administrative penalty of 160,000 US dollars and also imposed 6 million or 5,000 US dollars of the administrative fine against the TikTok. They found that TikTok failed to obtain the consent from the children under age 14 from their, like similar to other jurisdictions. Our law requires that in the case of the young children, they need to get a consent from the legal guardians of the children. So they failed to do so, and they obtained the consent. So TikTok was sanctioned, imposed a sanction of the administrative penalty.
The second issue is provision of personal information to third party without the data subject consent. In principle, the data subject consent is required in order to provide personal information. Please check the exceptions of the consent in this box. We understand that those exceptions are quite narrow. So usually, ICSP has to obtain separate consent to provide personal information. Especially ICSP, who fails to obtain consent may be subject to an administrative penalty up to 3% of the revenue related to the violation. And there are also criminal penalties. In this Facebook case, PIPC decided that Facebook provided the personal information of the data subject, who is the user's Facebook friend in this case, to third party, who is the third party app developer in this case. So without the data subject consent, the PIPA ruled that Facebook violated, the PIPC ruled that Facebook violated PIPA. The third issue is regarding PIPC's investigation. Under PIPA, if the PIPC become aware of any PIPA violation or allegations, PIPC can request certain information and materials from the company. And if the company fails to provide the requested material or submit the false information, PIPC can impose administrative fine up to 10 million won. In this case, PIPC decided that Facebook interfered with the PIPC's investigation by submitting false or incomplete materials. Maybe PIPC want to show even foreign service provider companies have to cooperate with PIPC investigation.
Last case is KPIC, the Korea Pharmaceutical Information Center's provision of patient prescription data without data subject consent, if it is that encrypted or de-identified data is qualifies still as a personal information. This case is a little bit very meaningful on the current situation, because even though this case is still ongoing, but the law has been changed last year, I mean the 2020, which I mentioned earlier. So, but anyway, I will very briefly explain about the case itself. The pharmacies actually, typically they have to, when they receive the prescriptions from the patients, then they put in certain information in the prescription paper sheet. And the KPIC's affiliate entity had actually developed a program called PM 2000, Palm Manager 2000 actually. And the purpose of this program is the assist to pharmacies to prepare the documents which is necessary to get an allowance from Medicare from the health insurance authorities. So they need to input lots of information in the, let's say, patient's descriptions, contents, doctor's name, hospital's name, when and what kind of the drugs or medicines has been sold to the specific patients. So lots of information is being made. But earlier of the 2011, the KPIC actually developed and upgraded this KPM 2000 and also distributed about 9,000 pharmacies in Korea. And under that upgraded version, whatever pharmacies they input the data in the PM 2000, that information is automatically de-identified or encrypted, especially in the direct identifier, has been encrypted or de-identified and then automatically sent to the KPIC. And once it is forwarded to the KPIC, then KPIC also sent to the IMS Health Korea, a Korean subsidiary of the IMS Health in the United States. And IMS Health Korea has also transferred that information to IMS Health in the United States. And IMS United States analyzed those data and made some statistics and then sent back to IMS Health Korea again. And then IMS Korea sell those information, the analytic data and the statistics to the pharmaceutical companies for profit, for businesses. And the key issue, this process was being done between 2011 to 2015, but later on those issues popped up, whether they actually, KPIC actually collect illegally about the personal information of the patients and then transfer to the IMS Korea, provided that personal information to IMS Health Korea. And the number of the data itself was largest ever in Korea. That means that there are 450 million prescription data, not the number of the data subjects affected, but the number of the record itself. This is the biggest one. The meaningful, interesting, this case is very related to and the impact or effect against the interpretation of the newly revised amended laws of last year, because PIPA actually, when they amended, PIPA introduced the pseudonymized data and anonymized data concept, and if it is pseudonymized data, personal information, then even though it is still personal information, you can transfer to the IMS Korea, third party, without consent from data subjects. If it is into certain for the certain purpose, which will be explained later. But what is the pseudonymization properly? Whether it is properly pseudonymized or not is all the time key issues. And even though different from these cases, the Korean governments actually published guidelines for the pseudonymization and anonymizations, and so this will be this kind of issues will be getting more and more important than before because of the big data and fourth industrial revolution areas. We need processing lots of the personal data, and so this case is very interesting and meaningful for your businesses if you are handling lots of the data, big data.
Kwang Bei, sorry to interrupt, you're on mute.
There are two cases here, two different cases. One is the civil cases, the other is criminal cases. The first case was civil cases. Plaintiff, I mean, the patients gather together and then they raise a damage claim litigation against KPICN, IMS Health Korea. And the High Court actually eventually dismissed such damage claims. And in these civil cases, there are two issues popped up. And one is that whether the encrypted data in this case still qualifies as personal information. And the second issue is whether KPIC and IMS Health Korea was liable to patients for damages.
The issues in this case is whether encrypted data qualifies as a personal information. On the PIPA, personal information is any information relating to a natural living person and one of the following things. First, identifies a particular individual. Second, even if it by itself does not identify a particular individual, may be easily combined with other information to identify a particular. Please note that the meaning of easily combined is very controversial. And because of this issue, personal information can be interpreted very widely in Korea. And last, pseudonymized information. As Kwang-Bei told that from August 5th, 2020, PIPA introduced the concept of pseudonymized information. In this case, court ruled that if personal information is encrypted or otherwise de-identified using measures that make it impossible to identify a particular individual, it no longer qualifies as personal information. Let's take a closer look. The table shows whether or not encrypted data qualifies as a personal information. You can see 3 stages of encryption. Stage 1, resident resignation number, RRN, is replaced with a 15-letter string of English alphabet character. For your information, RRN is very unique identifier that Korean government gave all Korean citizens when they born. And RRN normally cannot be changed. So if you have RRN, you can identify Korean citizen easily Because of this, now PIPA prohibit processing RRN, even you obtain consent of data subject. And stage 2, RRN is encrypted with one-way encryption using SHA-512. And stage 3, name, birth of data, and gender is encrypted with one-way encryption, not RRN. And the second instance court decided that all 3 encrypted data qualifies as personal information. But please note that this case is still ongoing in Supreme Court. So we have to wait and see the final decision. Now PIPA accepted the concept of pseudonymized information. So we don't need to obtain consent to process the pseudonymized information for the purpose of compiling of statistics, scientific research, and record preservation for the public interest. Second issue, liability of the KPIC and IMS Health for damages to the patient. Court ruled that both of them no liability because no personal information was divulged. And IMS Health used the data for the compiling of statistics. Last, the data was encrypted, so it was impossible for any third party identify specific individuals. Therefore, plaintiff did not suffer any actual emotional damages, court ruled. After the above incident, the PIPA was amended to include statutory damages provision. So now, plaintiffs do not need to prove their actual damages. Nobody can easily say that it may be the opposite on the statutory damages provision, but it may be more easily to be recognized the company's liability.
Hi, Kim Min, we appear to have lost your slides there. Excellent. They're back on.
Yes, let's move to the criminal ruling. Criminal court ruled that both of them not guilty. The reason of not guilty are both of them lacked intent to violate the PIPA. And according to the general principle of law, without intent, no criminal liability. To be specific, KPIC had no reason or motive to decrypt the data. And the collection of the data by KPIC took place before the PIPA went into effect. And IMS Health initially requested the encryption. And IMS Health had been implementing internal guidelines which forbade the decryption. Last, IMS Health had no reason or motive to decrypt data. Thus, the companies are not guilty. Court ruled.
Since the establishment of PIPA in 2008, the Korean data protection authorities has been taking data breach notification and reporting duties very seriously. Many organizations were imposed administrative sanctions for not notifying or reporting, and some cases even for not making the duty in a timely manner. Under the Integrated Personal Information Protection Law in Korea since last year, notification and reporting obligations for general data handlers and ICSP has maintained in dualized manner. And there are certain differences which may require attention. The most notable difference is in its deadline and scale of data breach. The general data handlers are required to notify and report a breach only when the number of affected data subjects exceed 1,000. And the deadline is within 5 days after becoming aware of the breach. By contrast, ICSPs are subject to the notification and reporting requirements in the event that even when one or more users' personal information get lost, stolen, or leaked. And time-wise, more strict standard applies to ICSPs that they are required to notify and report the breach within 24 hours. Practically, 24 hours is quite challenging due for a highly constrained organization from an emergency situation. If time and amount of work to prepare is taken into account, such as time taken for initial investigation, damage analysis, and evidence preservation, and so on, to allow a breathing room for such struggling organizations, the law allows to provide only known information first at the time of the notification and report, then update as further information become available. Notification to data subject can be made by mail, phone, SMS, and other equivalent medium. One other rule you may find interesting is that in addition to the personal notification, the general data handlers are also required to post notification on internet homepage or at the place of business for at least 7 days, which is a mandatory action. On the other hand, ICSPs can take optional notification or posting on internet homepage for at least 30 days in case affected users' contact information is unknown or there are other justifiable reasons. Other than PIPA, Credit Information Act requires financial institutions to immediately notify credit information subject in the event of data breach and report to Financial Service Commission or Financial Supervisory Service when 10,000 or more data subjects are affected. Also, Network Act imposes ICSPs reporting duty in the event of intrusion incident, even if personal information is not involved. In other words, any security incident must be reported to the government authority.
Chapter 4. This is a brief explanation of designation of CPO, CISO, and domestic representative. Especially for the foreign service providers, they have to check the designated CPO, CISO, and domestic representative when they apply with the Korean data privacy law. First, designation of the CPO. Who has obligation to designate the CPO? All data handlers. This means all data handlers must designate the CPO. And who can be a CPO? CEO or business owner, or practically an executive officer. And if there are no executive officer, the head of the department charging the processing of personal information. And 9 items of duty, especially establishing an internal control plan of personal information and establishing internal control system. So CPO oversees the processing of personal information within their organization. Second, designation of CISO. Who has obligation to designate the CISO? All ICSP, unless you are a very small company. Thus, almost all ICSP must designate one of their executive officer as the CISO. And please note that ICSP must report to the MSIT the fact that they designated CISO. Now, who can be the CISO? Member of the board of directors, or auditor, or anyone performing duties equivalent to executive officer. 7 items of duty, especially establishing an administrative system for information protection and preparing measures for information protection and designing security measures. Thus, CISO ensure the security of information and communication systems within their organization. Last, designation of domestic representative. This is similar to the requirement under GDPR to designate an EU representative. ICSP without an address or business office in Korea have to designate domestic representative. Please check the following criteria. The main criteria are annual revenue or annual revenue in the information and communication services sector, or number of the users. And last, it could be very unique. Any entity which has received a request for the submission from PIPC in connection with actual or possible occurrence of a violation of the PIPA. Who can be domestic representative? Entity or person having an address or place of business in Korea. The rule of domestic representative are duties of CPO, notification and reporting of leakage of personal information, and submission of document to PIPC. Because of the above role of the domestic representative, actually someone who understands Korean privacy law quite well would be suitable for the domestic representative.
Last one is kind of conclusion or takeaways from this session. Actually, Korea has witnessed a large number of data breach incidents and sanctions being imposed in relation thereto. So, just to look at the numbers in the first half of 2020, based on administrative sanctions actually imposed, the 36 incidents there was data breaches or sanctioned for whatever, maybe typically the violation of the TOMs or the privacy infringement, I mean, lack of the consent. And also the number of the personal information leaked are approximately 13 million items. So that number is not so big in considering the last 10 years or years of the breach incident. but due to Korea's very extremely complicated and tough requirement in the level of detail, it is very difficult to implement all TOMs or to comply as required by the laws. And in UK, during our these sessions, you saw that the causation relationship, I mean, there is a TOM violations, fail to implement TOMs, and whether it is as a result of that, there is a leakage of the personal information, or it's no relation with the kind of the just simply TOM violation, and the leakage is there. And then you may still subject to the administrative sanctions, not different from the criminal or civil litigation cases. But anyway, all the time TOMs are very difficult to implement 100% compliance, and this is the same to Korean companies. And Korean data protection laws are also prescribes a fairly stringent data breach notification and then impose the reporting obligation to the government bodies. And thus, if there is some violations or breach cases, then you should be cautious whether you should comply or follow the requirement under the Korean data protection laws. And finally, our regulatory authorities have shown, as you see in the Facebook cases, they have shown that their intention to strictly enforce Korean data protection laws even against the foreign companies. And it appears, at least for the time being. And so for our advice is that it is very important to assess compliance with the TOMs in advance and prepare contingency measures for the case of the occurrence in data breach or privacy intrusion cases. All the time it's not easy, and most of those are not easy, but there is no 100% safe and perfect solutions. So maybe each by company has to develop case item by items they have developed and assess and prepare. That is our conclusion. Thank you for watching.
Excellent. Thank you very much. Thank you to all three of you. Look, gentlemen, we have had some questions from the audience, largely about some of the technical measures that they can put in place. Do you want to address the questions now, or would you prefer to do so offline in a more considered fashion?
I think, yeah, I have briefly reviewed the questions, and I found that most of the questions are not kind of one single. It's not impossible for us to provide quick answers. It's really some technicals or sometimes it's fundamental questions. So it will take another time, another hour. So
sure.
I don't think we can do that.
Probably best to leave them. The questions that were relevant, I think you actually have addressed with this presentation. So look, it just remains to say thank you, a huge thank you to Lee and Co for wonderful presentation here, really stimulating, and thanks of course to you in the audience for joining us. Good day.
Okay, thank you.